Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a very important book which I think everybody involved in the practice of law should A, be aware of, and B, read in detail, because it affects everybody at all levels of our legal practice. And that's because it's dealing with something called the reform of civil litigation, which has been ongoing now for some time. This particular book is written by Rupert Jackson, who will be known to many people, a Lord Justice of Appeal in the Court of Appeal, Civil Division. It is about civil law, but I think what it does do, it gives a very good idea of judicial and government thinking at the moment as to where we're going in 2017 with these massive reforms which we're now undertaking. You're going to hear a little bit about what I have to say about this book in a few minutes. It comes to us from Thomson Reuters and the Sweet and Maxwell imprint, and also W. Green from Edinburgh. Let's have a look at the book first of all. It's only a little paperback. There it is there. You've probably seen it around. It's actually an important book. There's the actual spine, and then on the back you can probably see, if I hold it back a bit, some general comments which I have made some observations on, but because I think the book is really very important. Let's have a look at it first of all. There is a standard index at the back, very much the Thomson Reuters house style, and it's referring specifically to paragraph numbering in the actual document itself, the book itself. There's the start of the index. Next to the index is a bibliography. It's not a long book, by the way, it's only 250 pages. There are a couple of appendices at the back, and then what you do is you go into the chapters themselves. So we'll go to the front. There is the front page there, and then after that you've got all of the usual blurb there. Then you've got the various parts, the structure and the process of reform and the principles of proportionality. Then of course part 2, funding, part 3, consensual settlements, part 4, the management of litigation, and then part 5, particular categories of litigation, part 6, quantifying costs, and 7, conclusions with 2 appendices. Can I just say on costs that as I record this in January 2017, Jackson is producing a further update which is the subject of considerable controversy on costs for us to consider during this particular year. Now clearly that is looking very much on changing the costs regime again when it comes to fixed costs in the higher value matters, so that's something to look forward to, possibly, depending on your point of view. There's the foreword, which is well worth reading, which has come from Sir Terence Etherton, who of course is the master of the rolls. Then there's a note on parliamentary procedure by Lord Fawkes, my colleague Lord Fawkes, Queen's Counsel, who was actually at that time, I believe, the Minister of State in the Ministry of Justice. Of course he's no longer working for the government and is now just a member of the House of Lords. Then there's a main preface, and then after that, by Rupert Jackson, dated the 15th of June 2016, and acknowledgements of all the people who have been involved. The abbreviation is extremely useful. I've found that very useful because, again, there's an awful lot of abbreviation these days, and we do need to actually have for me, an idiot's guide as to what means what, because I do have problems sometimes remembering some of the abbreviations. The table of cases, not too many of them. Then there's a table of statutes, of course, as well, and SIs. Always have those. And then we start with the parts. You can see the structure. That's part 1, which is the process of reform. Then what you've got is you've got an introduction and you've got a little index, just to give you an idea of what's in the book, in the chapter rather. Then it runs through. There's the paragraph numbering at that side, and there are of course footnotes at the bottom. And it runs all the way through. It starts with Aristotle and ends up with old John Rawls. So it starts pretty well, and Bentham of course is there. So there's a lot of stuff jurisprudentially, even to kick us off with where we're going. And then of course you just go through the book. Judicature Acts mentioned, I shall mention those again in a minute. And then right in the middle, case management, for instance, is covered there, and the effective use of IT. There's the book. I thought it was a wonderful book, and something that has attracted a lot of favourable comment in the legal press. This is an important book and one that I think everybody should be aware of, as I say, and read. Now, what do Elizabeth and I say about this particular book in our review? Well, we say this: it's an important statement on the civil justice reforms from Jackson as we begin to experience monumental change in 2017. Excuse me. Now, that is really where the starting point is, and I think we've only really just started, because we've had a lot of problems with reform, and we need it because the internet revolution, IT, and all the huge changes again in the next couple of years are going to change the face of the way we do our legal business. It doesn't mean to say that lawyers are going to go. I know Mr. Susskind and other people suggest otherwise, but the fact is that we've got to be prepared for these massive upheavals. This is what we say anyway. It's an excellent statement from the incomparable Rupert Jackson, which actually appeared as a book in the summer of 2016, and I'm recording this a little way past that. And it's part of the civil justice process review, which, because we are now at the moment having a very substantial reform, which has continued with the most massive transformation of our system since the Judicature Acts of the 19th century. And I think it's fair to say that, without being too dramatic, that this is going to be the biggest upheaval since 1873 to 75. And it's basically a prominent record of his objectives, that's Rupert Jackson's objectives, which all practitioners should own and read, because you've got to get some idea of where we're moving at the moment. He's an incredibly able guy, and I'm very impressed with what he's tried to do, because this is no mean feat. Just like Harry Wolff's approach with the CPR, this one is the same sort of problem in another way, and you really do have to look at it from what I talk about as possibly wider concepts, so you've got some idea of the general movement forward as to where we go with civil justice in the future, whilst maintaining, of course, the rule of law and the integrity of the law for the users. Now, these reforms are urgently needed because we want a judicial explanation of what is happening to our legal system. This book, of course, in our view, gives practitioners a fundamental update and should be a mandatory acquisition for your legal practice. The only problem, as I see it on the horizon, is that it's not going to be the final word. Since the reform of civil litigation appeared, Lord Foulkes, as I say, left the government, although his note on the parliamentary process is, I think, one of the most important starting points to read. I found it very helpful, but obviously I know him and I know the way he approaches it, but I do think that that's a very useful starting point for lawyers, together with, of course, the Master of the Rolls, Terence Elton's excellent foreword, which again should be read. Now, in this current text, what Jackson provides is a concise explanation of his civil justice and costs reforms, ensuring practitioners can find clear and practical guidance on how they fit together. And Jackson's reforms had the objective, of course, which is stated here in the book, of reducing litigation costs and delay, thereby promoting access to justice, depending on your point of view, of course, but I think he's done it. This is the first-hand record of what the reforms aimed to achieve and the review of their success to date, drawing lessons from the process, giving us a most useful current update. Can I also say that you can't have a system of law which just stands still? That's one of the problems with a codified system, or the sort of problems we've had certainly with the written constitution, where you've got to consider amending, reforming and reviewing. And that's really where this sort of work comes into its own, because with the White Book, which we also use, of course, in court, we all know that it's only as good as the most recent edition. You've got to keep up to date. Now, the key point that Jackson makes include the following, and this is the list really of what's here. It's mentioned, I think, partly on the back, but certainly in the book itself. It's the following: abolition of the recoverable success fee, increasing general damages by 10%, a new test of proportionality, a ban on referral fees paid by solicitors to obtain PI clients, introduction of QOCS, which is the Qualified One-Way Cost Shifting. Which if you've had PI work, you'll know what that is, but QOCS is actually quite important. Introduction of fixed recoverable costs in the fast track and cost management above the fast track, promoting judicial continuity or docketing wherever possible, controlling disclosure and e-disclosure more effectively so that the costs of the exercise are proportionate to the issues in dispute. The introduction of more robust case management, here, and tougher enforcement of court orders, absolutely. Streamlining the process and processes for assessing costs at the end of the case and promoting ADR, or just dispute resolution as it should really be now, as a cost-effective form of dispute resolution. Now, those are the basic concepts that he's looking at. Now, most of us, well, there'll be a few don't agree, but most of us will say this is exactly the way we have to go forward, because enough is enough. I don't believe we're going to lose the basic veracity of the rule of law and the concepts of access to justice by doing it in this way. I know that some people disagree, but there have got to be some changes because we have to cut our cloth accordingly. We also have to be aware of the new generation of lawyers coming up, not old people like me, but much younger people who see what the future is going to hold for them and how they're going to handle disputes between parties. And that really is the basis of this excellent book. It's 3 years, of course, since the original reforms took effect, and with an ideal vantage point to survey their performance, Rupert Jackson not only sets out what the reforms aim to do, but draws lessons from the process and looks forward to where next for civil justice. And he raises the question of what further reforms are necessary and why we need them. Frankly, that's ongoing. It's continuing. The title scrutinises the management of litigation post-Jackson, because after all, he's not going to be there forever. Explaining the new regime of case and cost management, examining the issues and setting out the benefits. It explains the changes required to funding, looking specifically at CFAs, after the event insurance and damages-based agreements, which will be of assistance to PI specialists, of course. And can I just say here that I think we really do have to look at the issue of conditional fee agreements again, because I don't think they work in the right way at all. Myself, I've been very concerned about it because it's a double-edged sword when it comes to alleged access to justice. But that's for another occasion, but I do think that's going to be looked at again. Can I just conclude by saying that we consider that this book is intended to be of help also to the younger practitioner and to students who will, of course, be taking over from us in the future. It's an ideal resource for judges, for barristers, solicitors and academics who require an in-depth yet succinct insight into the most prominent and important reforms to civil litigation since the Wolf reforms. As I've indicated earlier, we owe a great debt of gratitude to Jackson for what he has produced, and I thank him here on the record for that. The publishers remind us, of course, that the book cross-refers to the second edition of Costs and Funding Following the Civil Justice Reforms Q&As, and is intended to be complementary to that title. The final word, of course, is not finished. It is just beginning, or in progress, as we might say. And it's, as I say, a big thank you to Rupert Jackson. The publication date, as I say, is given as June 2016. I'm recording this at the beginning of the new year, 2017. Here's the book again, purple cover. Nice little spine, and then at the back. If I just open it in the middle, disclosure. Here we go again. You can see the structure. Chapter 12, disclosure. A little bit of an index at the beginning, and then straight into it with the paragraph numbering and, of course, a few, but not too many, footnotes. I think one of the nice things about this is that each of the subheadings and the paragraph numbering is actually quite short. So you should be able to find what you're looking for quite quickly. But I think a quick read of this is well worthwhile, because if you are involved, as I am, in civil litigation, whether you're a barrister or solicitor, or in fact, for that matter, any of the backup services that go with what we do, and of course the judiciary, this book is absolutely fundamental. Thank you to all concerned. A special thank you, please, to Thomson Reuters in Sweden, Maxwell, and W. Green as well in Scotland for producing this for us. It makes our lives a great deal easier to have these books. Thank you to all. Bye-bye.